Welcome to Psychosocial Safety Briefings from the Psychosocial Safety and Leadership Institute. I'm Nicole Turnbull, and these briefings are designed to cut through the complexity and give you the essential information that you need to manage psychosocial safety in your workplace. Today, we're talking about significant changes to workers' compensation in New South Wales, changes that affect how psychological injury claims are handled and what it means for your organisation. Now, I'm joined by David Newey, who's a partner at Gillis Delaney Lawyers, who advises employers on these exact issues every day. David, thank you so much for joining us.
Morning, Nicole.
Can you share with us what actually changed with the New South Wales workers' compensation for psychological injuries and when does it take effect?
We've had a absolute poultice of legislation rolling out, and it's rolling out as we speak still.
Yeah.
We're not finished. There's more to come.
Mhm.
And that's because what we've got are new dispute processes, and we need rules around how they're going to operate. We've got new claims processes. We've got rules around those. We've got a whole set of changes to benefits and thresholds that give entitlements to benefits, which are quite draconian for workers, and will move a long way to reducing types of claims such as work injury damage claims.
Mhm.
So looking and keeping informed about all of those changes is going to be very challenging for businesses because the key changes have been to the Workers' Compensation Act
Mhm.
and the Work Health Safety Act and the Industrial Relations Act. So they're the changes, but we've got at least four bits of legislation which amend each one of those. Then we've got regulations overlaid over the top of that. So it's a terrible challenge. But I think the best way to start today is to sort of give everyone an idea of the key changes, at least insofar as psychological injury claims for workers' compensation are concerned. So
Mhm.
we had hot debates in Parliament over thresholds that would restrict entitlements to psychological injury claims.
Yeah.
So they're called the whole person impairment assessment thresholds. And there's been a tiered introduction of increases. So from the 1st of July this year, we're only able to bring a work injury damages claim if a 25% threshold is met for WPI. So then the next year, it increases to 26%, but not just 26%. It must be at least 26%, which means more than 26%. And then 2 years later, in 29, it increases to 28%. Now, originally they mooted to move it up to 30%. We heard pundits say that that would all but eliminate work injury damages for all claims because not many injured workers get to 30%. Um, my experience is not many people get to 25%. So reality is that the workers' comp claims for work injury damages will disappear or be very, very limited. Now, the thresholds are being used for something in addition. They're being used to restrict entitlement periods. So, what we have is they've introduced a cap of 130 weeks on weekly payments of compensation.
Yeah.
So, that's significant. You can get more, but only if you hit the thresholds. And then you only can get another 52 weeks. And then you can only get another 52 weeks if one, you're totally incapacitated, or two, you're back at work working for at least 15 hours and earning at least $225. So if you don't satisfy those two, you don't get the extra 52 weeks. So we've got a capping of weekly entitlements. In addition, we've got treatment costs. All you do is get 12 months of treatment costs from the last day that you've got weekly payments. So if you end at 130 weeks, you've only got 12 months more of treatment. That's it. Then you're back to Medicare. So it's a significant curtailing of benefits, which is quite difficult. Now, that's the primary driver of reduction in benefits. It's interesting when you look at workers' comp claims costs and their impact on employers' premiums, only the first $150,000 of a claim impacts on premium calculations. By dropping out work injury damages claims and just having 130 weeks of benefits, to me it seems like all of the claims cost, which would be about $150,000 if you looked at that, will now be taken into account in the formulas and calculating premiums, whereas in the past, anything above 150,000 was ignored. So the full cost of these psychological claims are intended to be factored into premium calculations. So we do have a promise from the government to stop premiums going up for a little while, but after that, they'll see how we're going with psychological injury claims and go from there. Now, another big change is that there's a new claims process and a new dispute process. The claims process is fast track for particular types of claims, being psychological injury claims arising from bullying, harassment, and excessive work demands. So only those types of claims. In essence, you grab a claim form, you put in a claim, it's got to be determined within 42 days, which is a real change. That's pretty quick when you think about the investigations that will need to go into ascertaining whether or not there's bullying, harassment, whether it's reasonable management action or the like. So, but that's the claim. That will be looked after by iCare's insurers at points and claims agents, and they will need to make a decision within 42 days. If a worker doesn't like it, they can request a review, and that review's got to be concluded in 14 days. And if the iCare or workers' comp insurers say, no, the claim is disputed, there is now a new dispute process. This is significant because this new dispute process is not in the Personal Injury Commission, where all workers' comp claims usually are dealt with. It's in the Industrial Relations Commission. It only relates to psychological injury claims from relevant conduct, not, for example, exposure to a traumatic event or a criminal act. That gives you a psychological injury claim, but you're not in this fast track and IRC dispute process. So it's quite interesting. So off you go, and you have a dispute as to whether or not there has been conduct that triggers the entitlement to compensation. To give employers a bit of comfort, we've had a whole lot of definitions included in this legislation. For instance, what is bullying, what is harassment, what is excessive work demands, what's taken into account when you look at excessive work demands. But the bad news for employers is, guess what? You now have a new dispute process. You will not have iCare managing that dispute process for you. You will find yourself needing to manage that dispute process in the IRC. You will find yourself paying for the costs of that process. And this is something terribly new for employers. And it's going to be a challenge as people get to learn how to manage the process. The advantage of this dispute process is that if there's a finding that there is no relevant conduct, there is no more compensation. There is no claim for compensation. It will also introduce the opportunity to employers to resolve matters during that dispute without the matter escalating to the compensation claim. Whilst the dispute process is happening, there is an interim payment system where you pick up some compensation, but there's no real claim. And that's the trick if they don't prove relevant conduct. The defences, really quite interesting. They've been beefed up. So if your psychological injury was, or if reasonable management action was a significant cause of the psychological injury, you don't get compensation. That's quite interesting. Secondly, if the worker's psychological injury is effectively a result of their expectation they've got some reasonable management action coming, then you don't get compensation. Then next is if you have a perception that the reasonable management action is not appropriate, that's not relevant and you don't get compensation if your injury is due to that perception, except where it's a reasonable perception. Yeah. And it's interesting, an objective test. Yeah. So there is a great deal that has just happened, and that's sort of just a very quick snapshot. And I feel like I've been rambling on for a long time already. So and there is so much that people need to come up to pace with. And we've got the legislation, and there's more to come. Court rules, court processes, regulations, and they haven't come. But the starting date looks like 1 July. So very interesting.
It is. You are definitely not rambling. I'm very grateful that we're having this conversation, and I know that other employers will be as well, because when legislation is introduced, it is quite confusing. So there is a lot of complexity around this. So talking to you is going to help with that. But you've also created some additional content articles, and we will refer to that as well. So thank you. Let's jump into, before these changes, how were psychological injury claims handled, and what's different now about how they're assessed?
In fact, it's important to know that because there is a transition period. So all of these changes are intended to be retrospective in terms of conduct. So if you've had bullying in the past, these changes are intended to apply to that bullying in the past for from 1 July. However, if claims are at certain stages, they will not apply to those claims. So if you've had an injury, you've been notified and you've lodged a whole person impairment application, then the changes won't apply to that. However, any conduct after 1 July, it will apply to. Any injuries after 1 July, it will apply to. And anything that hasn't reached those stages for the transitions, then it will also apply. So it's interesting. How does that happen at the moment? Worker puts in a claim form, and or the employer puts in a claim form. Provisional liability is usually accepted because psychological injuries are difficult to have a reasonable excuse not to accept provisional liability, because they're normally supported by a medical certificate, which is sort of the gateway to getting provisional liability. Then after that happens, there is usually an investigator appointed by iCare, and off goes an investigation where they'll come out and they'll interview the worker as well as all of the other people that may or may not have been involved in incidents that have led to the psychological injury. and also focused on reasonable management action. Now, at this stage, employers sit back, they cooperate with an investigator and the iCare to try to get that information together, and then iCare makes a decision. And it's quite regular that the decision is disappointing for the employer, because at the end of the day, perception is a very big feature of the compensation scheme at the moment. So if the worker has the perception they have been bullied, then that was enough. The game has changed, and in a significant way, it's shifting away. And it's only if that perception is reasonable that you're going to be able to bring that into the formula to work out whether or not you have a psychological injury. So moving forward, so in the past, we've had that process, which quite often leads to disappointment for an employer, a period of time off work, the statutory obligations not to terminate a person in the first 6 months following the accident, and then the exploration by an employer as to whether or not the worker is fit for the inherent duties of their employment or is likely to ever become fit, and if not, whether or not they need to terminate the worker because they never will come fit. So that's the process that we see today. There's no lump sum settlements of these claims unless they go to work injury damages. There's usually assessments of whole person impairment on the way through. So that's today's process. Tomorrow's process, I personally believe it will be throw it back to the employer to do much more of that investigation, because if the employer wants to dispute the process, it's going to have the evidence to dispute it in its possession, not done by the insurer. The insurer will still do a factual, but there probably will be more information that an employer needs to collect. Now, to have a claim disputed, it's got to do all that very quickly, because the insurer will be making a decision whether there's a dispute within 42 days. That's mighty quick, unfortunately. So, but what will happen is we'll find that insurers will be the gateway in the Personal Injury Commission looking at whether or not someone has got a psychological injury, and we'll have a gateway in the Industrial Relations Commission to see whether or not there's been relevant conduct that has caused that psychological injury. So that's how the pathways will separate. Now, I've had information find its way to me that the insurers are looking at having iCare's lawyers attend that IRC dispute, but not running the case, but as observers to see the process. Now, that's not been confirmed, but I think that's likely. And so the new system will give employers a raft of opportunities to resolve disputes, which may include exiting workers, may include making findings and admissions that there has been or hasn't been bullying, or the effects of it have ended. So there will be more to be developed, but there are at least some very, very strong defences that can now be mounted. And reasonable management action is one of those. And we've had some definitions around what's reasonable management actions, and a very long wish list, from allowing someone or not allowing someone to take holidays all the way up to performance management. So there'd be about 20 items that are given as examples to what is reasonable management action. But there is the two riders on it. It must be action taken in a reasonable way, and it must be action that is reasonable in all the circumstances. Hey, now, if you've got a judge or an arbitrator or a commissioner, minds different. Minds differ on what is reasonable. And so this will be the area of disputation that comes into reasonable management action defences. But at least we've got a better framework than we had in the past. So it's a real framework that sets out how you can defend claims where there's performance management and reasonable management action. So I think it's a big change, a very, very large difference to how these claims are going to be approached, and a lot more involvement from an employer up front, a lot more responsibility for the investigation. The onus will shift to them to convince the employer, in my view, that is the insurer, in my view, that the claim should be disputed, because that's a decision that has to be made before it goes off to the IRC. If you don't get it disputed, then you won't have any of this IRC dispute process. So it really shifts to be the employer's responsibility if they believe they've taken all appropriate action and the claim is should be disputed. You'll have to convince the insurers to do so.
Yeah. We could have so much more conversation about so many points in each of these answers. It's and we will. We're going to do another one of these. But not to share my opinion, I want to get the right information out. And I'd love to know if someone makes a claim for a psychological injury around, stress, anxiety, depression related to work, what happens now that's different before?
I just think there will be a larger focus on investigating the claim. With the benefits capped, it really doesn't save employers, because the premium impact I referenced earlier will be the full cost of the claim effectively. So it won't be any savings for employers. So, and you've got a person who's at work that you either need to manage their return to work or manage what's going wrong in the workplace that has led to the situation. Now, they're all challenges. It's not just a psychological injury workers' compensation matter. It's an entire problem for the workplace. A bullied person can run off to Fair Work and bring a stop bullying application. That's similarly for someone harassed. Someone can be terminated and they will have unfair dismissal claims, subject to thresholds being high income thresholds that take you outside of the regime. There are, even for local government employees, there is now a stop bullying and stop harassment jurisdiction in the Industrial Relations Commission, where people can get damages for injuries they suffer because of bullying and harassment. It's quite a significant shift, because that wasn't available to the public sector or local government employees in the past. So, and that jurisdiction is up, going and live already. That came in as a consequence of the amendments to the Industrial Relations Act. So that's been going for a little while now. So what we will see is a need to deal with the root cause of the problem. Secondly, we will need to make sure that everyone looks at a whole lot of their policies and procedures, because being clear about expectations is really the nub of everything. So if you have the policies, you have the procedures, and you have the people trained in your organisation to be able to manage what can be a very emotional period of time, then you are halfway there. Then a lot more documenting, a lot more consideration of matters, more risk assessments on those psychosocial hazards. These are all factors. And I see that workers' comp claims are only a small part of the overall picture, and that's the trouble. They are a cost burden on an employer, but at the same time, there are other things that need to be looked at and very carefully. And so it's interesting because when you come to reasonable management action and the list of items that can be, it's quite extensive. So every time you're interacting with a worker, then you are potentially exposing someone to harm. Correctly or incorrectly for workers' comp, it's not perception anymore. It's perception provided it's reasonable. So, and what's reasonable is yet another question. So it's interesting.
I think we're going to talk more about that in another session because there's a lot around reasonable management action, a lot more that we need to dive into. But you live and breathe this work. You are clearly an expert in the area. What are you seeing when it comes to psychological injuries? What are the types? What are you seeing claimed most commonly?
Oh, look, I think that unfortunately for employers, there's a wonderful thing called chat GPT or artificial intelligence. And so I typed into chat GPT a very simple sentence. I hate my job. I hate my boss. I want to leave and I want compensation. How do I do it? And so out popped a couple of pages of a very, very easy guide to say how to manipulate a system and how to put together some triggers that would allow someone to get compensation. So we've got that sitting in the background. And you can tell the complaints I see are clearly crafted by AI at the moment. And so that's really quite a problem. So, you're using terms like job creep. I go, who's using job creep in excessive work demands? It's a great example if it comes from an AI. So this is where all of that's happening. In addition, after that, we look at what's the real feeders. The feeders, traditionally, the larger claims have been sexual harassment. They have been the real large claims, little bit of discrimination. A lot of the largest cases where damages were awarded arose from racial discrimination. So they've been a lot. Bullying and excessive work demands seems to go hand in hand. It seems to be very much the same. Workers' perceptions are they're being bullied when they're being performance managed. And that's probably the greatest challenge that we've got. And they're the ones that we're seeing jump up now. So they're becoming much more frequent. So, and with excessive work demands, you've got to look at a whole lot of factors, and that's what the legislation tells us. How much you get paid, what the industry does, whether or not the contract gives you some ideas that there's additional hours you ought to work, what your role descriptions are, whether you've got a good defined role description. So there's a lot you can do to make it clearer. Then you have your dispute processes and your grievance processes, how to deal with that. But I'm also seeing that people are going more straight to disputes rather than trying to resolve a conflict or issues before that. So we now are with AI, instead of someone having a chat about what may or may not be going right, then all of a sudden we're finding that. Another thing I've found that happens is some employers are trying to set up check-in systems at the start of the day to make sure there's everyone's being listened to, looking at how workflow can do that. You've got to be so careful because some people that are doing that role take it as an opportunity to dictate terms rather than to listen to what might be happening. And so that can lead to a whole lot of additional problems, like demotivating people. So you have a morning catch up and everyone comes in and they feel like they've been slapped around the head rather than what the intention is to say, good morning, how's everything going? Is there anyone that needs a hand? And what can we do to help you? I mean, it takes a couple of minutes and it's a very simple tool to make sure that you're in touch with your team, but it can go wrong if you've got the wrong people that are managing it. So it's really important to have some skills, some soft skills around that. Otherwise, what you do put in becomes a problem. I remember in the old days when the Work Health Safety Act came in back in 1983, everyone ran off and got and bought manuals that ran into 50 volumes off a shelf. But they missed the point. The point is look at the risks, evaluate them, and see how you're going to address them. So it's a very simple process, but it is something that is new because a lot of people will not be used to assessing psychological risks, and that's the challenge. And we've spoken about workers' comp claims, but there's a whole raft of problems on work health and safety, which I know you want to touch on later. So we'll leave that till then.
Yes. And look, I've spoken to a number of leaders, and I know that you have too. And I think they're worried about, does this mean any worker who's stressed can make a successful claim, sorry. Where is that line?
Uh, I give you a terrible situation. It's like speeding. Everyone has a car, everyone drives down the road, and everyone speeds. Some people do it a little bit, some people do it with absolute disregard. So, if you are not feeling comfortable or you have an agenda, you can bring a claim. And so I believe there are a lot of people that bring claims that they are feeling uncomfortable, but it's a result of reasonable management action. And so there's no way to prevent that claim coming up. It's relatively easy to go to see a doctor, go online and get a medical certificate after providing a history of how you feel. It's very much like in WPI guides. It lists the criteria on how you need to respond to get to a particular WPI impairment and how it's evaluated. So people can inform themselves. The Internet of Things gives access to everyone information about how to bring claims, how to best present claims, how to make claims. So it's very, very difficult to expect these to slow down or stop. The only thing is they are not as lucrative for workers anymore, essentially capping them to 130 weeks of payments. So I've always said, if you can get someone back to work, your key assets are your employees. So if you can do your best and get them back and resolve the conflict, that's easy. But there will be people that will never go back to work because their intention is to never go back to work at that place. So, and you can't stop that. So, and so it's interesting.
It is. And you touched on reasonable management action a little bit. Can you just explain how that's changed as a defense?
They've introduced the two requirements. So the first is if reasonable management action is a significant cause of the injury, you don't get compensation. So that's really, it's got to be a significant cause. So that's a test. The word significance not defined. So we're going to have cases that will talk about what that means, and the jurisprudence around this will develop with time. And this will be out of the Industrial Relations Commission, not the Personal Injury Commission. So it will be that. And I think a lot of the problem, as I was mentioning earlier, was perception or expectation. So people who are underperforming, as an example, will be anxious about management action or performance plans being put in place. That doesn't give you compensation. So that's important to note. So their concern about that doesn't give you compensation. And then what they think about the action is irrelevant unless it's reasonable. Unfortunately, we've got to ask doctors sometimes what's the source of the injury. And it becomes very hard to be able to peel that down and say it's this or that or that. That's why they've used the term significant cause. It doesn't mean the only cause, it doesn't mean the predominant cause, but it will need to be a significant cause. So that will be more than a cause. So it will need to be probably the most prevalent cause. But we'll get some judges or arbitrators that will come up with how they're going to define that. So I think that's a really big issue. The second one is reasonableness in how you implement it, and reasonableness in what the action is. And the only way that you can best combat that is to tell people what the consequences will be if things don't happen. So it's before you even get to a dispute, this is where you build all your policies and procedures to make sure that you address how you will respond in the event that there's something. So when there is a grievance about excessive work demands, what are you going to do? How are you going to manage that grievance? What are you going to say other than, here's your job description, it's within your job description, and off you go? Because that's not the measure. And so the measure is really look at everything as a whole. How much are you getting paid? How much? So it's expectations. And I think that a lot of problems arise from not clearly articulating what the expectations of employees are. So, and we all know that it's a build-up process. As people are working away, they either will find that they're being overwhelmed and find that the work is excessive, or they might find that they're concerned that it might become excessive. Now, that's the one you want, because you can head that off. But you can't head the one off that's already, I'm making a complaint about excessive work demands. So, therefore, a couple of questions every now and then about how you're finding the job. Are you coping? Do you need a hand, etc., is really good. So those early morning check-ins have an invaluable benefit, but they have to be done right.
Exactly. Yeah. So what should employers, HR and work health and safety managers, what should everyone be doing differently because of the changes?
A lot of reading.
Yep.
Education is number one. So you need to sit back and educate yourself about some of these changes. And some of them come from work health safety that we haven't touched on in detail.
Yep.
But to me, work health safety is very simple. You have to do a risk assessment, because that's what we have to do for all risks. And as an example, even though there's all of these legislative provisions that's been enacted, there's also been changes to regulations, and in particular, the work health safety regulations. And now we have to comply with the psychosocial or managing psychosocial hazards at work code. We have a positive obligation to do that, not only in legislation, but in the regulations that came in last year. So that's on the table. When you've got risks, you've got to evaluate the risks, you've got to assess them, you've got to see whether or not they can be eliminated or whether they can be controlled. You have to put in control measures. So all of these become really important to start to look at and get your act together. Clear policies and procedures. Everyone's got to go back and have a look at your policies and procedures to make sure psychosocial hazards have been adequately evaluated and addressed. So that's a process. Now that's building a whole set of regimes that you probably haven't got documented properly. So then there's a dispute process you've got to look at, because you've got to be able to manage that dispute process. There's a cost of that you need to factor into all of these disputes, because that's now going to fall to the employer. There's other insurances than workers' comp. And so some insurances like management liability or employment practices insurance may cover either the defence costs and or perhaps settlements that you can exit people at the dispute stage in the IRC. So we've got a lot of change around that you need to focus on. You've got to have much better investigation processes and quicker investigation processes where there is a complaint and or a claim. So, and I put them in two categories. A complaint doesn't necessarily mean there's a claim. And so that's really quite significant. So you'll need to fast track it. Employers will need to upskill and have the ability to deal with iCare's scheme agent lawyers, because there's a panel of lawyers that are there. They'll be attending the IRC. They'll be interacting. So you'll need a team of lawyers that know this area. Then we have some of the more horrible things. We need to understand, if we're a unionised workplace, the rights of unions to do two things. One, to come on if they have a permit holder or delegate, union delegate who's a permit holder, to investigate potential breaches of workplace laws. And in particular now with digital work platforms that monitor and feed work and the like, because only a few days ago the government passed that legislation, which will come into play. Date hasn't been set, but it will be very soon. Now that's quite horrific, particularly for the financial services industry, insurers, banks, because a lot of what people do is monitor and feed work based on workflows and algorithms that we have in some platforms. Now, what's going to be interesting is to see how unions use their new rights to go in and have a look at these systems where there's a suspected breach, in particular around those awful privacy concerns that people have with data, and how it might be important to isolate data in a way that it's not part of the platform, so you preserve the privacy protection. So there's a whole lot of new challenges that are coming, not least of all that the unions now have power to prosecute for breaches of work health safety laws. Not carte blanche, not without checking with the regulator, but there will be checking with the regulator, and unfortunately, the regulator will find they're in a rock and a hard place, because if they do nothing in terms of a prosecution, the unions will step in. And there's a financial benefit in that, because unions will seek orders that the fine is paid as a moiety or direct to the unions, rather than to safe work and invested back into enforcement, and also however else safe work uses the money it receives from fines. So you sit back and I go, there's rewrites of policies, there's got to be reconsideration of people's strategies on providing suitable duties, which is an obligation under the Workers' Compact, and how you're going to deal with that with someone who's got a psychological injury. Very challenging. These are not easy matters to deal with.
And that's why we're having this conversation, and we will have another conversation that dives into the union powers in work health and safety, because there's a lot to unpack in there. But when it comes to when employers receive a psychological injury claim, what's the biggest mistake that you're seeing them make?
Put it in the drawer. It's the problem is employers need to listen, because there are either toxic relationships in the workplace that can cause that. There can be processes that are problematic, that can lead to problems. There can be personality conflicts that are as simple as not being able to manage that. And people's expectations of what their job is generally are not quite the same as the expectations of the employer, particularly when it comes to excessive work demands. So what's excessive for one may not be excessive for another. And that's why it's really important to know that it's all a bit of what's fair. So if you expect a bit of overtime, that's not excessive work demands if you're actually compensating people for that by paying them additional money. If the industry has a particular style of how you work, if you're adhering to that particular style, there's not going to be excessive work demands. If you're paying penalties and shift allowances and the like, that's another factor that's taken into account to see if there's any excessive work demands. But everything happens because there's a mismatch on expectations. And that's the problem that we're always going to have. And there will always be mismatches. It's just how you can ultimately resolve that. So, and consultation is important. You can do surveys, you can do that, but generally you don't get adequate information just from surveys. You need to be working with your team. And that's really what it is.
Definitely. Have the conversations, don't ignore it. And I think a big theme that's coming out of all of this is preventing it from occurring in the first place, which will save you a lot of time and hassle for everyone. So what can organizations do now to reduce the likelihood of valid psychological injury claims?
Communication.
Yeah.
It's not much more than that. And communication from one, being involved with your workers, to having managers that understand that's the way it has to be, because they're the ones who are at the coalface managing people's expectations, articulating your expectations very clearly and without any concerns. And you can tell people, particularly when you hire, if you are very clear in what your expectations are when you hire, it's very hard to say, well, I've got excessive work demands, because that's the role that you've been hired for and that's where you're going. So it's front-ending everything is much easier, but the trouble is you will not avoid claims, disputes, and complaints. It's managing them, it's documenting them, it's working through them in a way that you can do that. I see that workplace mediations, which is not something that has taken off significantly, will become more of the norm because there's going to be that need to deal with conflict between people. There are some mediators trying to eke out a living as mediators in workplace disputes, but not a lot. It will grow with time. And so, and it is difficult when you've got two people warring or at ends of the equation that you need to bring together, particularly if you need to keep them working together.
Yeah.
But so many doctors say a person can't return to that workplace. And so there's not much you can do if someone says this is just going to be a continuous problem and expose someone to further aggravations if you put someone back in that workplace.
Yeah.
So it's very hard to manage suitable duties, but that's why you've got to have these processes clearly documented and articulated. Training for all of your people that are managers is crucial.
Yes, definitely. So just to kind of wrap up, I really enjoyed this chat, and I'm looking forward to the additional ones that we have to dive into other areas to help make it easier. But if someone has a psychological injury claim lodged tomorrow, what are the three things that they should do immediately?
Give their insurance broker that's managing their claims a quick telephone call is a really good start, assuming that you have a person that will help you. But the more important thing is to have a project plan on how to manage the claim. From the initial complaint to informing the worker about what their rights are and what your dispute process is, letting the employee have an opportunity to read your dispute processes and procedures so they can actually understand where they are and hopefully see there's more than a formal complaint process, that you can explore informal resolution of issues. Then once you do that, you make sure that you've had a good chat with the worker, made sure that you've identified all of their concerns and see whether or not they wish to proceed formally or informally, and if they wish to proceed formally, to do so and make sure that they feel safe and heard. So it's relatively simple what to do. It's all about having a game plan on how to investigate what's gone wrong. Now, once you've done that, you found out what's gone wrong, you've got to go back and fix it so it's not going to happen again. And so these claims and complaints actually lead to opportunities to improve and enhance the workplace. So, and reduce the risk of further interaction hazards or that. Hey, but sometimes you'll find you've got bad eggs. Sometimes you'll need to deal with terminations because people have breached your policies. So it's get a claim, listen, lodge it, do the investigations promptly, very promptly, get a hand from people that know how to do the investigations. It's not always easy for you to do them internally. Sometimes it's safer to get someone external to do the investigation. It helps a person listen, provide the information without any great concerns, and understand exactly what the issues are. So there's a 10-step process probably you could design. It could be 20 and it could be 50, because there is so much you can do when you get one of these claims. It pops up. And I just simply say thorough investigation, proper listening, and dealing with the consequences is important. But you do need a set of skills that I don't think many employers are going to have because they haven't had to deal with the negotiations with iCare to have claims disputed if there's a real issue. And so that's where I think that employers need to be heading is building the resources that they can use in the event that a claim does arise. And they've got a strategy to put that in play day one.
Mm.
I talk to insurance brokers all the time about how they're going to manage these types of injury claims and what they're going to do to help employers that have these claims. And at this stage, they say, well, do we have the rules? No, they haven't been written yet, but they will be before 30 June. But we know what the process is. Investigate, identify whether or not you've got any valid defences, beef up the evidence that you need for those defences, provide it to the insurer, convince the insurer to dispute it, and have your relevant conduct dispute. If you've got that. My greatest thing is that you would never dispute things that you don't have a valid reason to dispute. And that's the key point. And one of the interesting parts is the government has got insurers with an obligation now that their lawyers have to sign off on a certificate that says, hey, this case has reasonable prospects. And on top of that, the costs of disputing this are not excessive, having regard to the potential size of the claim. Now, the insurers will have to sign off on that. So there's going to be some pushback from the insurers disputing claims. So I see that the real challenge for employers is the beefing up of disputes with iCare's lawyers about disputing claims.
Mm.
So I see that's something that's going to be quite challenging.
This has been an incredible conversation. Thank you, David. This is such a complex topic, and we are going to have many more chats about this, but I really appreciate your time, your perspective, and the balance that you're suggesting. And I love the note that you landed on. If you find the problem, fix the cause so that you don't have to be in this cycle. So I think that's an incredible way to end off our very first psychosocial safety briefing. Thank you so much for coming on. I really appreciate it.
Lovely joining you. You're welcome.
And just for everyone listening, we will link through to David's full articles in the show notes and as well as some more information. And if you need specific legal advice on a workers' compensation claim, you can find David's details there as well. And this has been a psychosocial safety briefing from the Institute, helping you navigate psychosocial safety with expert guidance and practical tools. We will be back with David talking about the new union powers in work health and safety enforcement. So make sure you subscribe so you don't miss that one. Thanks, David.
Thanks, Nicole.